Get ready for the dictation. Start. This judgment and order shall dispose of the present writ petition and connected writ A numbers 19265 of 2021 and 19267 of 2021, all of which involve identical questions of fact and law. Writ A number 19263 of 2021 is being treated as the leading case. Heard Mr. Ashok Kumar Singh, Learned Counsel for the petitioner, Mr. Jeevan G. Srivastav, Learned Counsel appearing on behalf of respondent number 3, and Mr. V.K. Nagaich, Learned Standing Counsel appearing on behalf of the state. The brief facts of the leading case are that the late Kamla Prasad, father of the tenant petitioner Chandan Lal, was allotted shop number 6 on the basis of an auction dated 29/8/1990 for a period of 99 years. The shop is owned by the Nagar Palika Parishad, Gopiganj District, Bhadohi, and the Nagar Palika, represented by the executive officer, is the landlord of the said shop. The rent of rupees 250 per month was settled, besides a premium of rupees 30,000. The case of the petitioner is that he has been regularly paying rent to the Nagar Palika Parishad, but without determining his tenancy, the Nagar Palika Parishad have issued a recovery certificate dated 5/11/2019 for a sum of rupees 93,508 claimed to be outstanding against the petitioner on account of unpaid rent. The petitioner challenged the order dated 5/11/2019 before this court, wide writ C number 37670 of 2019, on the ground that the petitioner's lease has not been determined, yet a recovery citation has been issued. Substantially, the recovery citation was objected to on the ground that the petitioner is not in default of payment of monthly rent, and further, that he has already deposited all outstanding rent under Section 30 of the UP Act number 13 of 1972. It was contended, therefore, on behalf of the petitioner in the writ petition last mentioned, that the petitioner cannot be said to have committed default in payment of rent. The writ petition was contested by the respondent Nagar Palika Parishad on the ground that the provisions of UP Act number 13 of 1972 do not apply to the Nagar Palika Parishad owned buildings in view of the provisions of Section 21A of the said Act. Therefore, deposit of rent in court under Section 30 of the Act under reference would not inure to the petitioner's benefit. A further objection raised on behalf of the Nagar Palika Parishad was that the petitioner was not at all a tenant and the lease pleaded by the petitioner was denied. The writ petition under reference came up for determination before a division bench of this court, and their lordships were of opinion, considering the stand of the Nagar Palika Parishad denying the petitioner's tenancy, that disputed questions of fact were involved which cannot be decided in a writ petition. So far as the fact that the Nagar Palika Parishad, being exempt from the operation of UP Act number 13 of 1972 under Section 21A thereof, no deposit under Section 30 could be made is concerned, this court held that the Act would not apply to a Nagar Palika Parishad. It was also remarked by the division bench that the question whether a sum of money due to the Nagar Palika as rent can be recovered as arrears of land revenue is also a disputed question of fact that cannot be gone into. In view of the findings, the division bench directed the district magistrate Bhadohi to decide the matter in accordance with law after hearing the petitioner as well as the Nagar Palika, subject to the condition that the petitioner deposits half of the sum of money due under the impugned recovery certificate within 15 days of the date of that order with the respondent Nagar Palika Parishad. It was further directed that the petitioner would deposit the rent/damages at the rate of rupees 1000 per month in future. It was provided that subject to compliance with these directions, status quo with regard to possession, nature and character of the property in question would be maintained. The district magistrate Bhadohi was directed to decide the dispute preferably within a period of 3 months of the date of the order under reference. The petitioner was granted liberty to adduce evidence in support of his case. The order further provided that in case the petitioner commits default either in depositing half of what was shown recoverable under the impugned recovery certificate or in the matter of deposit of current rent/damages at the rate indicated and within time, the benefit of the order dated 21/11/2019 passed by this court would not be available to the petitioner. Stop.